What if number 3? What if you became incapacitated? What if you had a stroke? What if you had dementia, which is how my mom died? What if, God forbid, there was a serious accident? What if you went into coma? What if? The question you have to ask then is this: who's going to pay your bills? Who's going to manage your investments? And let me stop with that one before I go on to the other ones. A lot of misconception I'm finding in this area. I'm going to break this down for those of you that have investment accounts, which I know is the majority of you. I'm going to break this down to qualified, meaning IRA type of accounts, and non-qualified, meaning taxable accounts, joint tenants, individual names, that type of thing. So on the IRA side, it's pretty simple. Usually, at least with our clients, most of our clients, if they are married, will name their spouse as the primary beneficiary. Really simple. Let's say the husband dies, the wife brings in the death certificate. Usually it's, last one we just did, about 6 weeks it took to get the death certificate. But we can't do anything on that until that point. We can't distribute the money. We can't take investment instructions from the spouse, even though she's beneficiary in this example. We can't do anything because there's no power of attorney on file. See there? So that's what happens on IRAs. Again, once we get the death certificate, attorneys look it over, everything looks good, then the money moves over to an IRA of the spouse. Okay, pretty simple. The taxable accounts, however, are quite different. If it's a joint tenant account, joint tenants' rights to survivorship, the most common we see, then no problem. The spouse just continues operating the account. We have to open a new account, usually just in her name if she doesn't have a trust. But there's really no major problems, with the money getting over to her because it's joint tenants' rights to survivorship. Surviving spouse gets the account. It's just the time period to get that money over to the other account. And again, if there's volatile market conditions, sometimes a day seems like an eternity. Or if you had a trust, there's no change in any accounts. Okay. But what if it's an individual account? What if that client of ours was divorced, widowed, whatever the case is, or they just never married? We have a lot of clients that have never been married. Then guess what happens? At that point, we can't do anything. So typically what happens with us, we get a phone call from a child or a friend that may be listed as the successor trustee. But usually it's the child. So I'll go down that example. Child will say, just want to let you know that dad died last weekend. What do I do? Well, guess what? We can't do anything. Why? Because it was a taxable account. Taxable accounts do not have beneficiaries, unlike the qualified IRA accounts. So we are frozen. We can't make buy decisions. We can't make sell decisions. We can't do anything until we hear from the probate court and we have a written document signed by the judge. What happens? Do you think that's not frustrating for us? What happens if the market starts plummeting and we want to get we get all of our clients out of the market, but we can't get this client out? We have no legal authority as the brokers to do that. You have no legal authority either, because all you are is you're going to be the executor of the will, but you can't do anything as the executor until the court says you can do something. And again, that can take months, sometimes years, but usually months. So you see, who gets to manage the investments if you don't have a living trust? Nobody. If you don't have, like I said, somebody that's on the account with you. Who can make the medical decisions? Right? My gosh, I could do an entire show on that. Who's going to know that you want to be on life support? You're not want to be on life support. One of the big questions we have in our estate planning documents, I want hydration, I want nutrition, but only under these circumstances. No one's going to know that. So as I've always said, remember your medical staff is, your doctors, Hippocratic oath. Their job is to keep you alive. That may not be what you want. So again, I can go down an entire path on medical decisions. You get the point. So the big takeaway of this, what if, is the following. Please remember, folks, estate planning is not about death. It's only about death, I should say. It's also about protecting you and the people you love while you are alive. People fail that. They always think, oh, estate plan, yeah, I'm going to live forever. I don't need anything. It's not the case. There's components, as you just learned, of the estate plan. The advanced directive, which is the financial powers, the medical directive, which is the medical side of it. Those are things that are applicable to you while you are alive. And don't think age has anything to do with it. Again, any of us could get into a car accident in the next hour. Anything can happen to us. But if you don't have the estate plan in place, guess what? You're leaving it up to people you don't know or maybe not even trust to make those decisions for you. All right, I'll come back with what if number 4.